Okay, I need you to clear your schedule because we have a lot going on and none of it is calm as usual. Ticketmaster employees got caught on Slack calling ticket buyers stupid and bragging in writing on a work platform in a federal trial about robbing them blind. Taylor Frankie Paul and her ex filed restraining orders against each other on the same morning, 1 hour before their court hearing. A jury found Elon Musk liable for misleading Twitter investors. Caitlyn Jenner filed a creditor's claim against the estate of her late friend who died 9 months ago at 29. And we're trying something new called I'll Be the Judge of That, which I think you're going to love. Welcome back to Exhibit A List. I'm Jasmine Wegg. I'm your host. I'm an attorney, and this is where pop culture gets cross examined. Every Monday, I take the stories that everyone is already talking about and tell you what is actually happening legally. Because most of the hot takes miss that legal nuance. And let's be honest, when the law is involved, we need the nuance. You deserve the full picture. You can find me on Instagram, Jasmine WeggySQ, and the podcast Exhibit A List Pod. On TikTok, I'm Jazz the Lawyer. DM me any of those places. Please don't forget to follow, rate, review, and share this podcast with anyone who needs a lawyer bestie in their life. Let's get into it. So I wanted to start with the Live Nation story because it's the most underrated story of the week and it directly affects every single one of us. You know that moment when you're buying a concert ticket online and you found the seats and you click through, and then of course suddenly the price jumps $40 in fees, and you're like, "What's happening? I thought it was going to be 100. Why is it 150? And why is this legal?" So here's the background. The DOJ, the Department of Justice, filed an antitrust lawsuit against Live Nation Entertainment, which owns Ticketmaster, back in 2024, arguing that when Live Nation merged with Ticketmaster in 2010, the combined company used that control over venues, promotion, and ticketing to lock out competition and drive up the prices for the fans. The DOJ wanted Ticketmaster broken off from Live Nation entirely. That is a big ask, and that would change everything. The trial started back in March in New York. 1 week in, Live Nation and DOJ announced a settlement. $280 million fund, some adjustments to how venues can choose their ticketing provider, and an 8-year extension of their existing consent decree. There were no admissions of wrongdoing. But here's the crazy part. The judge found that the settlement, he had not been informed when they were negotiating behind his back, and he called it unacceptable in open court. And then after that, most of the state plaintiffs refused to sign. So as of March 16th, 36 states and the District of Columbia looked at the deal and said it was not enough. The trial has continued without the federal government. 36 states on their own are going up against one of the most powerful companies in entertainment. Now, during the trial, before the settlement, something entered the court that is super interesting. Internal Slack messages from a Live Nation employee, a former regional director of ticketing who oversaw a large amphitheater in Florida. These messages were produced in discovery and were played out in open court. In those messages, he described the people buying the tickets, you, me, anyone who's ever stood in a Ticketmaster checkout wondering what facility charge actually means. He called us stupid, so stupid, and he bragged about robbing them blind. Crazy, huh? Now, that quote is an internal Slack message on a work platform, subpoenaed through legal discovery and read by a federal judge. Live Nation's response was that the messages were off the cuff banter and that they did not reflect the company's policy. Leadership said that they only learned about them when the public did, which is its own kind of statement. But beyond just being viscerally satisfying, in an antitrust case, one of the core things that you have to prove is that the company used its market dominance to actually harm consumers, that prices were inflated beyond what a real competitive market would produce. So when your own employee is documenting in Slack that he knows that he's overcharging people and he considers them stupid for paying these costs that are just tacked on, and he frames it as robbing them blind, that's a direct evidence of knowledge. And it goes straight to what the state needs to prove in an antitrust case. Live Nation has argued that breaking them up won't lower ticket prices because touring is genuinely expensive, artist fees are high, the economics of live music is complicated. And that argument might have merit in a vacuum, but it's significantly harder to make it when you're standing next to a Slack message from your own employee bragging about robbing all of us blind. If the state wins and gets what they're asking for, the structural separation of Ticketmaster from Live Nation, I think that would benefit us all of us who like to go to live shows, and it would reshape how concerts are ticketed in this country. So these trials are ongoing, but these are the cases that are important for us to watch because they do directly impact us. If we're going to shows and seeing things live, we are paying these fees and we're questioning them but unable to make changes. And in the courts right now, this is how the changes are coming about. So these are important for you to watch because this one is about your money every time you try to see someone live. Okay, we're returning back to Taylor Frankie Paul because there's more news about her. And a quick catch up for anyone who needs it. Taylor Frankie Paul, the Secret Lives of Mormon Wives cast member, who was cast as the lead of The Bachelorette in 2023, she was arrested for aggravated assault after a physical alteration with her on again, off again boyfriend, Dakota Mortensen. She pleaded guilty and has been on probation ever since with a felony plea in abeyance. And the probation was set to end in August 2026, 4 months away. And a new 2026 incident between her and Dakota now is under investigation. ABC ends up, of course, as we all know, pulling The Bachelorette season 3 days before it was supposed to premiere after TMZ released 2023 footage of the altercation with her daughter in the room. So here's the latest that has happened. Dakota has filed for a protective order and gotten temporary custody of their 2-year-old son, Ever. Taylor was cut off from parent time until the April 7th hearing, which was 2 days ago, as of the time of this filming, which is happening on Thursday night, April 9th. 1 hour before the hearing started, Taylor filed her own restraining order against Dakota. Her filing included photos of bruises on her arms, legs, and face. She alleged that he slammed her head into a car dashboard on February 23rd. She alleged a separate assault in May 2025. And this detail is that and one detail she noted was that on Valentine's Day 2026, after their breakup, Dakota tattooed her initials, TFP, inside his mouth and then sent her photos of it. He showed it to cast members on set. She called it alarming, and I'm going to go ahead and call it alarming too. In light of everything, it is strange and alarming. So both of them walked into court that morning with active restraining orders filed against each other. The judge told the courtroom that he had concerns running both ways, and the outcome was Dakota kept custody. Taylor got supervised visits up to 8 hours a week with Ever in 2 or 3 hour increments until a follow-up hearing is held on April 30th. After the hearing, Dakota's attorney issued a statement saying that the hearing was used by the respondent, so that would be Taylor, to assassinate Dakota's character as a dad whose only concern was for the welfare of his son. They said that they'd tell the true story at the hearing on the 3rd. So that's in other words, this lawyer is playing a little PR move and teeing up for the next chapter, a standard move. Dakota has now been edited out of Vanderpump Villa Season 3, which premieres on April 16th. This was announced on April 3rd, meaning it took Hulu weeks after the story broke to make that call. Meanwhile, ABC pulled Taylor's entire Bachelorette season same day, immediate. Dakota is still appearing on YouTube competition series produced by Alex Cooper that dropped this week. So why, when allegations go in both directions, and in this case they genuinely do, both sides have filed protective orders, submitted photo evidence, given written accounts of abuse, why does the woman's career consequence happen immediately, but the man's seems to happen on delay? It took a while for Vanderpump to move away from him. So I'm not defending what Taylor did. You all know that I don't stand behind anything she did. The footage was horrendous. But I just think that there's a real question why we pull the woman right away, But the man, he gets this like buffer period. It's just something that we should all think about. The bigger legal issue is still the probation question, however. We don't know whether her probation will be considered violated by these new altercations and whether she will now have to face that felony charge. But moving on, we have an interesting story about Caitlyn Jenner and her friend Sophia Hutchins, who had just passed away 9 months ago. She was 29 years old. In July 2025, she died in Malibu, driving an ATV rear-ended a car on a cliff road and went over a 350-foot drop. Horrific tragedy. It was sudden and terrible, and by all accounts, Caitlyn said she was devastated. However, in November 2025, Caitlyn Jenner filed a creditor's claim against Sophia's estate for $439,095. In March 2026, Sophia's estate agreed to pay the full amount. So here's the breakdown from the court documents. Sophia had authorized access to Caitlyn's credit card and debit cards for work purposes. The agreement was that personal spending would be paid back. According to the filing, it wasn't. At least not all of it. Over $273,000 in credit card charges on platforms like Shopify, eBay, over $133,000 in shared legal fees, $16,000 in debit charges, $7,000 in cash advances. So to the internet, this sounded spicy. She filed against her dead 29-year-old friend's estate. It's cold, calculating, but a creditor's claim against the estate actually is a little bit different. When someone dies, their estate goes through probate, the legal process of sorting out their assets and debts. If someone owed you money when they were alive, you have a legal right and often a limited time window to file a formal claim against the estate. So it's not a lawsuit against a dead person. It is the legally correct way to collect debt that existed before a person died. If you don't file within that window, you typically lose the right to collect at all. That's the law. If Caitlyn had legitimate money owed to her and Sophia's own estate agreed that she did because they allowed the claim in full without fighting against it, then filing the claim is not cold. It's how the process works. The alternative is absorbing nearly $500,000 in expenses that were supposed to be repaid and just letting it go because it feels uncomfortable to ask a dead person's estate for it. Here's the part that matters legally. The estate allowed the claim. That means that the people managing Sophia's estate on her behalf viewed the documents and did not dispute that the money was owed. That is not nothing. Whether Caitlyn should have filed is a question about grief and relationships and what you owe the people you love after they're gone. And that's for each person to make individually. But whether she was legally entitled to file given the evidence and the estate's own response, the answer to me is a resounding yes. Now, moving on to your boy Elon Musk, March 20th, 2026, after a 3-week civil trial in San Francisco, a jury found that Elon Musk is liable for misleading Twitter investors. The case is called Pampina versus Musk, a class action brought on behalf of people who sold Twitter shares between May and October 2022, stretch when Musk was publicly going back and forth on whether he was actually buying the company. So here's what happened in 2022. Musk agreed to buy Twitter for $44 billion. Then he got cold feet. He started posting tweets questioning whether Twitter's bot and spam account numbers were accurate. On May 13th, he tweeted that Twitter deal temporarily on hold pending details. And then he made some other tweets. The Twitter stock dropped almost 10% in a single session. The investors argued that these tweets were not genuine concerns about bots, that he had done something calculated so that he could negotiate a better deal for less money. That's super shrewd. Twitter eventually sued him in Delaware to force him to honor the deal. He reversed course and bought it at the original price. The jury found him liable on these two tweets, but the jury did not find that he was trying to do a broader scheme to defraud the investors. But they did find that his tweets were misleading. But here's where the story gets weird to me. The jury had to fill out a verdict form calculating how much Musk's tweets depressed Twitter's stock price for each trading day over 5 months. The figures ranged from under $3 to over $8 per share, and exactly one number $4.20, dated August 9th, was highlighted in blue ink. Only one number out of the months of daily figures. So if you know anything about Elon Musk, which I learned when I was researching the story, that 420 is a number that he's attached himself to repeatedly. Most famously, the 2018 funding secured tweet announced he'd take Tesla private at $420 a share, which prompted an SEC investigation, and which he later had to testify under oath that it was not a marijuana joke. The jury in San Francisco in 2026 was aware of all of this. The blue ink was not an accident. His attorney, Alex Spiro, filed a letter to the judge calling it bizarre and highly questionable, arguing that the jury used its verdict to mock Mr. Musk and that the highlighted $4.20 was a commentary not on whether Mr. Musk committed securities fraud, but on the jury's views about Mr. Musk himself. So here's my honest take. Did the jury make a joke? Yes, probably, almost certainly. Is it funny? I think so. But does it give Musk legal grounds to overturn the verdict? That is a much harder argument, and I don't think there's much teeth there. The standard for jury misconduct requires a showing that something actually infected the deliberations and produced an unjust outcome, not just that the jury found someone annoying. Writing one number in blue ink is not the same as reaching the wrong answer on the law. Musk's team has filed objections to the judge entering the final judgment, calling it premature, saying that he's planning to appeal. His official statement called it a bump in the road. And now, Joe Exotic. Guys, if you remember the pandemic and being stuck inside, I think most of you, like me, will remember Tiger King. Joe Exotic, real name Joseph Maldonado Passage, age 63, is currently incarcerated at the Federal Medical Center in Fort Worth, Texas. If you watched Tiger King, and I think that we all did, he was convicted in 2019 on 2 counts of murder for hire and multiple wildlife violations. Murder for hire charges are for hiring 2 separate people to kill Carol Baskin, the animal rights activist who ran Big Cat Rescue and has been his bitter rival for years. He was sentenced to 22 years. Later, he was resentenced to 21 after a procedural issue with how some of the counts were grouped. He has been fighting this conviction through every available channel since the day that it happened. His most recent attempt, the one that has just reached the Supreme Court, argued that witness testimony at trial was unreliable. His lawyers claim that several government witnesses later recanted and that prosecutors failed to disclose deals that they made to encourage those witnesses to cooperate. That would be a Brady violation, named after a landmark Supreme Court case, and is one of the most serious post-conviction claims in criminal court because it goes directly to the fairness of the trial. So the arguments were reviewed, and the court said that even accepting the recantations, the remaining evidence was sufficient and it would not have changed the outcome. On March 30th, the Supreme Court denied his petition with one line, no explanation, which is standard when SCOTUS declines to hear a case and they don't tell you why. They just said no. When the Supreme Court turns down a case, it's not a ruling on the merits. The court is not saying whether he's guilty or the lower courts got it right. It means that 4 justices, the number required to grant cert, did not vote to put it on the docket. They did not vote that they want to hear this. The conviction stands not because the Supreme Court endorsed it, but because they didn't touch it. So now he's left with very narrow options. He can keep filing post-conviction motions in the lower federal court. He's actually been asking Donald Trump for a presidential pardon since April 2020 when Trump said he'd look into it. Trump has not acted on it and has not mentioned it since. At 63, serving 21 years, with the Supreme Court door closed, presidential pardon is realistically his best remaining shot at freedom. And now we're going to do a new segment called Lovingly. I'll be the judge of that. It's a listener Q&A, and it's exactly what it sounds like. You send in the questions, and I'll answer them. Feel free to email your questions. I'm not giving legal advice, but just life advice from a lawyer, and they'll stay anonymous. You can email them to exhibitalistpodcast@gmail.com. Send me your questions, and I will be happy to answer them if I can. So the first question reads, I'm a new attorney in a small firm with barely any support staff. That means like secretaries or paralegals. My boss keeps asking me to do non legal work, making copies, picking up lunch, basically being an assistant. What do I do? Guys, this one hits home because I have lived this. I have been you. And here's what I wish someone had told me when I was new because I was doing those things. I was grabbing the waters for the meeting, picking up the lunches. If you don't say something early, you will continue to do it. You will do it begrudgingly. You will build silent resentment, but you'll do it because your boss told you to. And eventually you will rage quit or just continually look for jobs, even though there's a chance that you might have liked this job over not being able to speak up and assert yourself. Your boss will never see it coming when you do quit because you never made it known that you were unhappy about these things that they're asking you to do. So my advice is don't explode or silently seethe and take it and just look for something better. Handle it professionally head on. Say, hey, I want to make sure I'm using my time in the way that's most effective and useful to the firm. I have these skills as an attorney. That's where my training lies. I think that my hours are best spent being billed as an attorney, and maybe we need to bring on some help for these admin tasks that you've been asking me to do lately because it doesn't seem to me like the what you would want me to be prioritizing. And the reason I suggest this is because if they push back and they want you to continue doing those things, then your answer is clear and you know from the get-go that you need to look for something else because it's not a match because you are an attorney and you should not be doing errands or working as an intern. But if you give them the opportunity to make things better and you show that this is not something you're okay doing, then they can fix things and you can find happiness at the job that you're at and make sure that you're doing fulfilling, interesting work. Your time is allocated right. Because the truth is that in a small firm, a lot of times the business owner is a senior attorney who maybe is not that experienced in business and might fail to see how to best use their employees in the right way. And they're taking advantage. You're there, hey, why don't you run and do this? Why don't you do that? They're not thinking smartly with their money either, and it's important that you speak up. Don't make it an accusation. Don't be dramatic. Just clarify expectation. And if your boss is responding defensively, then you have different information about where you work and you can make a better decision about how to go forward. Your boss is not just going to have a revelation one day and suddenly stop if you haven't said anything. So do this now, early, before you're 6 months in and furious about a sandwich. Question 2. My friend keeps constantly coming to me with the same problems over and over and never takes my advice. I always end up exhausted. What do I do? Okay, I call these people an asshole, and this is an asshole situation. And I say it with genuine love. But an asshole is someone who just gathers advice, not because they plan to use it, but because the act of processing their problem with someone else is the thing that they want. The energy of it, unpacking it, feeling being heard, validated, someone supporting them and saying that they hear what they're saying. And the advice itself is beside the point. You could give them the most perfectly calibrated response in the world, and nothing will change because solving the problem was never their real goal. And once you see that, it's going to shift everything because you don't have to go full therapist, lawyer, guru every time. When they come to you, try this. Meet them with ugh, that sounds really hard. Validating that it is a bad situation that they're in, that they're coming to you for, and you feel for them, you sympathize, and then just move on, move the conversation along. Don't ask the follow-up questions. Don't do the deep dive. If you've already done it and you see that they don't take your advice, but that they are just kind of being a friend vampire and energy sucking from you, let them find somewhere else to do it. And trust me, they will. You don't have to do it if you're not up for it. If you've done it already, it got nowhere, bow out. Say that stinks. I'm sorry you're going through that. I really hope things resolve. And you know what? That might not be super satisfying for them, but that might make them not come to you again the next time they want to rehash that same story over and over. Listen, you're not abandoning your friend, but you are protecting your energy, which means you can actually show up for her in the long run when something is big versus always being that sounding board where you provide this like excellent advice that should be A level and it's getting wasted on someone who really wasn't there for the advice. Hope that helps. Question 3. Someone in my life is constantly making passive aggressive comments. How do I handle it? Passive aggression, they hate to see direct energy coming. That's why you gotta hit them with the direct. Passive aggression is actually designed to build a sting without being accountable. They comment it with a smile. They give you the little jab, the little dig, but it's wrapped around plausible deniability. You can't even quite say, like, were they trying to insult me or not? It's so subtle. The person doing it is counting on you to absorb it quietly or react badly and look like the problem. The move that dismantles it every single time is your directness. Ask them, why do you say that? What do you mean? Calm, neutral, give them genuine curiosity. Why do you say that? Make them say the thing out loud with their chest that they're trying to say in a roundabout way, passive aggressively. Most passive aggressive people have never been asked to actually defend the implication that they make. They get away with it because we all roll our eyes and allow it. If you don't want to be the victim of passive aggressive energy anymore, ask a direct question that's genuinely curious and make them defend that statement that they're saying to you, or they'll back down, they'll backpedal. A lot of them will apologize. There's usually not a very good thing that they would be able to say to defend what they said, and that's the core in getting around passive aggression. The whole game passive aggression plays only works if you react to it like you're supposed to, like they want you to, by absorbing it and letting it eat at you, subconscious when you think about it later in the shower, or blowing up at them. So reflecting it back to them makes the game stop because they don't like directness. Passive aggressive people can't stand a direct person. Stay neutral, let the silence sit, ask why they said it. The direct wins every time. Well, guys, that was episode 28 of Exhibit A List. I'm so glad you came back for another week. We covered a lot today. Ticketmaster calling you stupid in writing, Taylor and Dakota filing against each other, Joe Exotic officially running out of courts to appeal to, Elon Musk losing a jury with a sense of humor, and that fun little I'll be the judge of that segment. This is why I do this every week, because the headlines are everywhere and the actual legal analysis might sometimes be missing. Please leave a review if you've been listening and haven't yet. It genuinely helps more people find the show. I see every single one. Send in your questions so I'll be the judge of that. And find me on Instagram. Please screenshot you listening to the podcast and tag me in the stories. I would love to repost it. I will see you next Monday. Court is adjourned. Stay curious, my friends.